Good afternoon, everyone, and a virtual welcome to the Warren B. Rudman Center for Justice, Leadership, and Public Service at the UNH Franklin Pierce School of Law. My name is John Graby, and I direct the Rudman Center. I'm so pleased that this fall, we have been able to partner with the New Hampshire Institute for Civics Education to present a series of William W. Treat lectures on matters of vital importance to the civic health of our nation. Senator Warren B. Rudman, our namesake, believed deeply in civic education and bipartisan problem solving. So this partnership is very much in keeping with his legacy. This afternoon, we present a conversation entitled Protect and Defend the Constitution, the Significance of the Oath of Office. The topic of today's conversation could not be timelier. I'm very pleased at this point to introduce Martha Madsen, the Executive Director of the New Hampshire Institute for Civics Education. Martha will provide a bit more background and introduce our speakers. Martha?
Thank you, John. The New Hampshire Institute for Civics Education is very grateful to partner with the Rudman Center for Justice, Leadership, and Public Service here at the Law School to bring you this timely discussion on the meaning of the Oath of Office. And I'm thankful to John Graby for chairing our Treat Lecture Committee. This series of lectures, and there is one more to come this fall and next year, were made possible through the generosity of the William W. Treat Foundation. Like Senator Warren Rudman, Judge William W. Treat was a believer in the respectful exchange of ideas across party lines in order to advance the public good. William Treat was an advocate for human rights, a diplomat, a New Hampshire probate judge, author, and a banker. He served as a public delegate to the United Nations General Assembly, and we are honored to host these lectures in his memory and to continue his legacy. I would like to also thank our constitutionally speaking partners, New Hampshire Humanities, the New Hampshire Supreme Court Society, the New Hampshire Institute of Politics at St. Anselm, Citizens Count, and of course, the Rudman Center at the UNH Franklin Pierce School of Law. I hope you had a chance to see the photograph of our New Hampshire Kid Governor, fifth grader Susie Brand, swearing in her executive council last January in Representatives Hall in Concord. If you didn't see it, the photo is featured prominently on the homepage of our website. I hope that you see the solemn, earnest, respectful way that these young people made their promises through their oath. As an educator, I'm always considering how local, statewide, and national events are affecting our youngest citizens. I'd like to extend a warm New Hampshire welcome to our speakers tonight, and I'd like to introduce our moderator, Dr. Janet Breslin-Smith. Dr. Breslin-Smith draws on her 30-year career in public service, including leadership roles in the U.S. Senate, the National War College, and in Saudi Arabia, where she focused on outreach to women in the Middle East. She is co-author of the National War College, A History of Strategic Thinking in War and Peace. She was the first woman to chair the Department of National Security and Strategy at the War College. She served as Deputy Staff Director of the Senate Agriculture Committee and as Legislative Director to Senators Patrick Leahy and Donald Stewart. I know her best as an active trustee on the board of the New Hampshire Institute for Civics Education. Dr. Breslin-Smith will be introducing our esteemed lecturers and moderating a discussion between them. There will be time for questions from the audience during the last 20 minutes. Please post your questions to the speakers in the Q&A function. So yes, we are looking forward to hearing what your questions are. And thank you all for spending this afternoon with us in New Hampshire. Let's begin.
Great. Well, Martha, thank you so much, and welcome to all of you who are joining us on the webinar. I know there are a great deal of our alumni from the National War College who are joining us this afternoon, and we appreciate that. As you all know, and certainly Judge Stucky was a student of mine at the War College, and he turned out so well. It is a remarkable place and a treasure, I think, for our country. I know it was an honor and a privilege for me to teach there for about 17 years. So honestly, it's my great privilege to introduce our two speakers. Judge Stucky, as I mentioned, was a graduate of the National War College. He was a judge advocate in the United States Air Force. And when he left that, he also had a remarkable experience that he shares with Maggie and myself, is that he worked on Capitol Hill. He was the Republican counsel on the Senate Armed Services Committee. And I knew him then also. I remember taking our students up to the Hill on numbers of occasions, and both Senator McCain, who Maggie worked for, and the committee itself was so generous with their time with our students. And then Scott was nominated to be on the U.S. Court for Appeals for the Armed Services, and now he serves as Chief Judge. Maggie Goodlander also has had a broad breadth of experience. She serves on the advisory committee for the Rudman Center. And again, it recalls my days on the Hill when Senator Leahy and Senator Rudman had such a good working relationship. And I get nostalgic for that era when McCain and Rudman and honestly, on both sides, Senator Warner, all worked together in that period of time. Maggie also is an adjunct professor right now of constitutional law at the UNH Law School. So Judge Stucky, I want to have you start. Again, it was an honor to have you as my student, and I hope to learn from you again this afternoon. So please, your reflections about this very, very deep question for all of us. What is the oath of office, the significance of it?
Well, I first took the constitutional oath much later than these kids in New Hampshire. I first took the constitutional oath on the 31st of May, 1970, the day I was commissioned in the Air Force. And like most Air Force ceremonies of that sort, they had a real swearing in, and then they had one for the moms and dads. The real swearing in was done at about 9 o'clock in the morning in a ratty old World War II building, in a classroom, the ratty old World War II building that we held ROTC in. It was about as unpromising a surrounding as you could have. What feelings did I have about it? I remember a feeling of deep obligation that I was doing something exceedingly important that may well change the course of my life, and in fact it did. But more than anything else, I remember, I think, a sense of deep importance of what I was undertaking, and a sense of deep obligation to the nation. Now, since I was trained as an historian before I ever went into law, I want to talk a little about where all this came from. If you look at the Constitution, it's in Article 6, which has a lot of stuff in it, including the famous Supremacy Clause. But there's something else in there as well. The last clause of Article 6 of the Constitution says that the senators and representatives before mentioned, i.e. in Article 1, and the members of the several state legislatures and all executive and judicial officers, both of the U.S. and of the several states. And this was an innovation. You're making the states swear allegiance to the federal Constitution. Shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. Oh, there are 2 points about this language I want to make, and they're both inclusionary, and they were certainly inclusionary by the standards of the 18th century. The religious test language, where'd that come from? Why did they put that in there? Well, in 1787, the Test and Corporation Acts were still in effect in England. The Test and Corporation Acts were Restoration era statutes that required office holders under the Crown to take the sacrament in accordance with the rite set out in the Book of Common Prayer. In other words, you had to be a practicing Anglican to qualify for public office under those statutes. From the 18th century onward, dissenting Protestants, Protestants who weren't members of the Church of England, were allowed to get around the requirement by a series of annual indemnity acts, but that was a matter of grace and not of right. The statutes continued on the books in 1787 for their real purpose, which was to keep Roman Catholics out of public office in England. And they weren't repealed until 1829. So right at the beginning, you have inclusion, no religious test for public office under the federal public office. Now that doesn't cover the states, and in 1787, several states still had ecclesiastical establishments, especially in New England. But as far as the federal Constitution was concerned, anybody can step up and hold office. The other point, which is a somewhat more subtle one, is it says oath or affirmation. Affirmation is in there to include Protestants who had conscientious scruples against swearing oaths, primarily Quakers. And again, you see the inclusiveness. You may affirm without swearing an oath and hold office under the Constitution of the United States. Now, of course, this oath requirement dates to the Constitution, dates 1787. We had a country before 1787. We had an army before we had a country. So what'd they do then? The original enlistment oaths taken by members of the Continental Army simply promised obedience to the original Articles of War, the disciplinary code that governed the Army. When independence was declared in 1776, they rewrote the enlistment oath to promise fealty to the United States of America and honorable and faithful service and in opposition to their enemies, and obedience to the officers, to the Continental Congress itself, and to the officers set over the men by the Continental Congress. The officers took an oath, which at the very beginning was kind of long and lumpy because you had to list all 13 states. But what the officers basically said was that, one, they acknowledged the United States, the 13 states, to be sovereign and independent. Number two, you declared that the people of the 13 states owed no allegiance to George III. Three, you personally renounced any allegiance to George III. And fourth, you promised to protect and maintain the United States against George III and all his successors. And there it was. When you got to the Constitution and Article 6, you started to get something approximating what you've got today. You've got an enlistment oath, that's in 10 U.S.C. 502, which is, there you go. The enlistment oath, the enlistment oath promises fealty to the Constitution, but the emphasis in the enlistment oath is on obedience to orders. I will obey the orders of the president and the orders of the officers appointed over me according to regulations and the Uniform Code of Military Justice. For officers and for the officer's oath set on Title V, and it basically promises fealty to the Constitution, This oath is taken both by military officers and by civilian officials of the United States. You swear that you will support and defend the Constitution. You're not supporting and defending the president or any person. You're swearing and defending the Constitution against all enemies, foreign and domestic. You bear true faith and allegiance to the Constitution, and that you take the obligation freely without any mental reservation, and you will well and faithfully discharge the duties of the office on which you're about to enter. So what's that mean? Well, number one, particularly in the military context, the fact that an oath is sworn to the Constitution as a document, as a thing, as the basis for our government, implies to me absolute political neutrality. And except for a few dangerous times in the early Civil War and some others that I won't mention, we've had that out of our armed forces. The armed forces of the United, one of the great blessings of life under this Constitution has been the fact that the armed forces have maintained an attitude of strict political neutrality. Most officers carried it to not even voting. Most high-ranking officers, George Marshall was an example, refused to vote until after World War II because they thought it tempered their commitment to complete political neutrality. Now, in the case of the civil service, it's a little different because during much of the 19th century, of course, you had to the victors belonged the spoils, and the civil service were tossed out whenever you changed administrations, and they were expected to be partisans of the party in power. But since the 1880s, you've had the Civil Service Commission, now OPM, and since the 1930s, you've had the Hatch Act that imposes political neutrality on the career civil service. So political neutrality is an absolute must. Obedience to orders, and especially in the case of enlisted people, and serving faithfully and against all enemies. If you look at they tinkered with the officer's oath at the beginning of the Civil War and stuck in some provisions that basically required you to swear that you had never aided any rebellion against the United States or anything like that. But after the rebellion was squashed, those were taken out. And by the 1880s, you basically had the constitutional oath that you have now, which is a very fine, succinct summation of the duties that military personnel and civilian civil service owe to the country and owe to the people of the country. Now, I want to mention one more oath, and then I'll be quiet. Justices and judges of the United States take the constitutional oath. In addition, they take an oath that's prescribed in Title 28, which is strictly judicial. And in that, the judge solemnly swears that he will administer justice without respect to persons, do equal right to the poor and the rich, and faithfully and impartially discharge and perform all the duties incumbent upon me as judge under the Constitution and laws of the United States. And of course, one of the essences of being a judge is absolute neutrality politically, at least on the federal level. Now, of course, it's different in the states, but absolute neutrality politically and absolute neutrality with regard to the litigants before the judge. That is a vital and precious thing. And that's why this oath requires that. And with that, I'll shut up.
Well, thank you. I mean, honestly, that's a great beginning. You know, you were teasing me before, but like when the majority leader, Senator
Yes.
Byrd, always had the Constitution in his pocket. And we give it out
Hold
here.
it out at every...
Here we are. And in Salem, New Hampshire, where I live, we have a day at our fall festival where we give this out to anybody who would like it. And then we also have a little test to see how much people remember from whatever education we have. And we obviously endorse it in our institute to enhance our understanding of the Constitution. It's a brief document, but
it is. I always make that point to my federal courts class at GW. The whole thing will get on 2 pages. The whole thing, the first 10 amendments will get on about 3 pages. It's staggeringly concise and concentrated, and that's why you have to read it with such care.
Right. Sometimes there's in our high school here in Salem, we have a civics class, and we do an exercise sometimes where they sit down, and if they were on an island, onto themselves, how would they organize themselves? And it's a wonderful exercise to see if you're starting from scratch, how would you establish, again, liberty, order, representation, all these questions. So Maggie, I'm going to put it over to you because, again, just like Judge Stucky, you've looked at this issue from various positions and perspectives.
Thank you so much, Janet. And thank you to the Rudman Center and to the Institute for bringing us together. I'm so glad to be you and Judge Stucky. So my interest in the Constitution in a way is an accident of birth. I was born here in New Hampshire in Nashua on election day, and my daughter broke when she was in the voting booth. And I think the rest is history and you know, the present. So I'm teaching constitutional law right now, but I've spent the better part of the last decade working in each of the branches of our federal government. And I've had jobs, as you said, Janet, I worked in the Senate and in the House. So Article 1, Article 2, I'm an officer in the U.S. Navy Reserve. And Article 3, I spent 2 years clerking as a law clerk to 2 different federal judges, to Merrick Garland, Judge Merrick Garland on the DC Circuit, and Justice Stephen Breyer on the Supreme Court. So these have been experiences in each of the 3 branches, but the thing that is unified the experience is the oath of office that I took before each of these jobs. And it's the same oath that Judge Stucky was just talking about a moment ago. And it's an oath that is required under Article 6 of the Constitution, but the words are in statute. And I want to sort of, I'm excited to unpack what these words mean to support and defend, to bear true faith and allegiance to the Constitution. But I thought I'd just sort of build on what you were saying a minute ago about the document itself, because the thing, you know, there are sort of, as I see it, 5 basic parts to the oath, but they're all directed towards this thing, this great document, the Constitution. And so I thought I'd just say a few quick things about what the Constitution means to me, because that's ultimately what we're swearing an oath to. So I think, you know, the way that I think about it is the Constitution is really, it's a compass. It's a compass that is written obviously in the written word, and it's the oldest written roadmap for self-government in human history. But as you both said, it is admirably concise. There are 7 articles, there are 27 amendments, but the whole thing is it's just a little over 7,000 words in total. So if you take anything away from this event, I hope what has been great for me in preparing for this, it's been a while, I taught my class together with John Grebe. I recorded it a few months ago. So it's been a while since I've had the chance to actually read it through cover to cover. And I hope that that's one thing you'll take away, because the text is really written in an accessible way. It's written in a way that it can be understood by any and all Americans. It's also, so just 3 quick points. You know, the first is it's very practical. The framers were students of history, but they were deeply knowledgeable about human nature. And they understood a few basic things. They understood that in order to build a workable government, power had to be divided. And they divided power very carefully between, ultimately, the ultimate source of power is the people, but 3 co-equal branches of the federal government and the states. So everyone's got skin in the game. And the framers did a masterful job of thinking about the relationships between these actors in our constitutional system. So it's a practical document, but it was also, in addition to being old, short, accessible, and practical, it's also revolutionary. You know, I think of the music from the musical Hamilton. The world will never be the same. And it's true. And the reason for that is really simple, and it's contained at the very beginning of the document. It tells us in the first 3 words, we the people, that this is a different kind of government. It is a government whose legitimizing source is the people themselves. And this was revolutionary at the time, and you know, it obviously, this version of the Constitution, I hope yours does too, Janet, for the people of Salem, includes the Declaration of Independence. And it's important that it does, because the Declaration is really the promise. And the Constitution is the framework, the compass that allows for the fulfillment of that promise. But it's the promise, as we all know from the immortal words of the Declaration, you know, I think of it as 3 basic, we declared 3 things: that all men and women now, we can say, are created equal, that there are certain inalienable rights, life, liberty, and the pursuit of happiness. And most importantly, that to secure the rights, we have government. And our government depends, and this brings us right to the preamble, on the consent of the governed, on we the people. So the final point is this: you know, the rights that our Declaration declared, they said were self-evident, but they are most certainly not self-executing. And the Declaration acknowledged that. It's government that ultimately secures those rights. And there's nothing inevitable about our government, as you know, we're reminded in many ways every single day. You know, Ben Franklin, I think, as usual, said it best when he was asked what kind of government we have. It's a republic if we can keep it. And so this is why the oath matters, the oath that the Constitution, and there are multiple oaths, which I hope we'll talk about, you know, embedded in the Constitution, required by the Constitution. But it's the fact that we have to even keep the republic. Keeping the republic requires keeping faith with the experiment, with the project of the Constitution. And keeping faith, you know, asks of each of us some simple things, you know, some basic things. We all have to pay our taxes, and the Constitution has a lot to say about taxes. We all have to serve, when we're called upon by our fellow citizens, on juries. And the Constitution talks about 2 different kinds of juries. We are all called upon to vote. And the Constitution has a lot to say about voting. You know, the amendments, the 27 amendments to our Constitution, talk more about voting than any other issue. But, you know, above all, we as citizens have got to uphold our oaths if this experiment is going to work. And so that is how we keep faith, and that is how we keep our compass alive and working and well. So I'm so glad to be with you, and look forward to unpacking 5 USC 3331 and other questions. Oh, Janet, I think you're on mute.
It's the watchword from our times. I'm on mute. I I appreciate both of your perspectives, and I'm going to engage both of you right now, but I encourage the audience to send in questions right now, and I'll take a look at them in a few minutes. But if I could just start off with an observation, and Maggie mentioned other oaths, and it caused me at the time, just in the last few days, to look in Saudi Arabia. And I remember when we lived there, and the oath that is administered certainly to their ambassadors when they take their position, it's to Islam and to the king and to the homeland. And when we first got there, I said, well, do you have a constitution? They do have a national act, but the first response is the Quran itself is the constitution. So it's a different notion. It's a different culture, obviously a different history. It's a different notion of what this is. And that it always brings me back to this, because this is paper and it is an idea. And so I thought you might want to comment about, in your professions, have you encountered this idea of different concepts of constitutions and also the oath?
Well, I found it interesting to see the English oath in this collection, because of course in England they swear fealty to the Queen and to her successors. But in English practice, and certainly since the beginning of the 20th century, and nothing in England ever happens suddenly. But from the early 19th century forward, as the crown gradually withdrew from partisan politics, when George III was there, the crown was knee-deep in politics. But swearing an oath of allegiance to the Queen, who in constitutional practice is above politics, is to me remarkably like swearing an oath to the Constitution of the United States. It's a person, but she's above politics, and that's the only way it works. And you promise faithful and true allegiance to Her Majesty Queen Elizabeth II, her heirs and successors, and I will, as in duty bound, that's the law, that's the language of feudalism. Honestly and faithfully defend Her Majesty, her heirs and successors in person, crown, and dignity against all enemies, and observe and obey the orders of Her Majesty, heirs and successors, and of the officers set over me. So in that case, it tracks the American enlistment oath with regard to obedience, and the oath of faith and allegiance is to the crown in its sense of being above politics.
And then as I look at the Pakistan one, also it's reflective of, and looking at the other ones is on our screen right now. Again, it's a different relationship. Also, Scott, you mentioned this about no religious requirements. Yet in other cultures, that's usually the leading aspect.
Yeah, here it's there's a very strong religious test. You have to swear that you're a Muslim and you believe in the tenets of Islam.
Right. So one thing I know, and I think Scott remembers this, at the War College, every year we would take our students to the Supreme Court. And every year it was an honor and a privilege for us. Justice Scalia made that, I think, the high point. And he would address our students in the chamber, in the courtroom. And he always had a talk, and he's given it many times. And I think his last time I saw it was to the Federalist Society, shortly before he passed on. And the point he made, at least it made an impact on me, is that he would, in his thundering voice, would talk about what is it that protects our liberty? What is it that protects us from tyranny? And he said, it's not the Bill of Rights, that any nation, I think he said like a two-bit dictatorship, could have a beautifully written Bill of Rights. I think the Soviet Union, I think he said, had a beautifully written rights to everything.
In the Stalin Constitution.
Right, right. And so he would talk about that. And he goes, it's not the First Amendment, it's not the Second Amendment. what protects you in your rights is the structure. It's the structure of government. It's the Constitution itself in the structure of government. And as I left, when the students came back to seminar, my own reflection about this, because I asked myself the question, and maybe I'm going to ask both of you when you worked on the Hill. I thought about it because as a staffer in Congress, I took the same oath. And I remember thinking one day when I was working on agriculture and on dairy legislation, and it was agony. We were doing the authorization bill and then the appropriations bill, and the House wouldn't go along with us, and the Senate was falling apart, and the president was threatening to veto. And I thought, this is too hard. And then all of a sudden I had this feeling that the framers were looking down at me from above and smiling because they wanted it to be hard. They wanted power dispersed, and they wanted it to be not so much efficient as it was effective in bringing people together. Because by the time we got an agriculture bill done, if I could get the wheat growers from Kansas to agree with the dairy farmers from Vermont or New England and the oil producers in the cost of running all that equipment on the farms, if I could get them all to agree on a bill, I knew that there was stability in that. So I don't know if you wanted to comment on having that Hill experience as well as both your military experiences and your academic experiences.
Yeah, I think, just to pick up on Justice Scalia's observation that the Constitution depends entirely on structure, I think he's absolutely right. And that to me is the practical piece of it. The framers understood human beings. They understood that, and I think you look to the Federalist Papers and what Alexander Hamilton wrote, and James Madison too, don't want to forget him, that ambition needs to be checked by ambition, that we have three co-equal branches of government at the federal level, and we have the states and the relationship between the federal government and the states, but at bottom you've got the people. And I think, the separation of powers and checks and balances that our system has, as I said at the outset, it's an undeniable piece of genius. And I think it is related to the oath, because when you swear to support and defend the Constitution against all enemies, foreign and domestic, I think what you are pledging to is to support and defend the Constitution by using the Constitution, by using the systems, the remedies that the Constitution itself sets out in it to solve problems of self-government. So you have in the Constitution the answer to how at bottom do you create a government of, by, and for the people? Well, you do that through elections. And the Constitution is very, very clear about how elections happen. It says a whole lot about it. As I said, in the 27 amendments and in many of the articles, 1, 2, and other articles too, at least 2 of the 7 thoroughly cover elections. We know how self-government is actualized through the right to vote. And we also know how the peaceful transfer of power happens under our Constitution. And the 20th Amendment and the 25th Amendment make clear that that happens in fact, the Constitution sets a specific date, January 20th, and a specific time, 12 noon, for the inauguration of a new president. Structure is, and also I would add, I worked most recently as a counsel to the House Judiciary Committee during the most recent impeachment proceedings, the impeachment of President Trump and the Senate trial. And the Constitution, once again, sets out a substantive standard for how impeachment works. Impeachment is itself a remedy in the Constitution for abuses of power. And it's clear about what role the House plays, what role the Senate plays. And in describing the Senate's role, in fact, the Constitution once again requires an oath, a specific oath that senators take when they sit as jurors in a court of impeachment. So when there is an impeachment trial, senators take oaths. And the Constitution says that when a president is impeached and tried before the Senate, the Chief Justice presides. So we have clear, not only just, gestures towards remedies. We have clear rules of the road on how it's the compass is not just decorative. But I think I'd conclude by saying where I depart and disagree with Justice Scalia is I would emphasize just as important to our Constitution and to the oath that we take, alongside structure are the values, the underlying values, and the principles and the rights, frankly, that we are bearing true faith to and that we are swearing allegiance to. And without that, without the uniquely American values of self-government and the enumerated rights, this is just scaffolding. It's not a home for a people for all of time.
I used to think, and maybe Judge Stucky can talk about this. I remember when I was reading, history, constitutional history of our government, the idea from the framers of civic virtue and values and participation. And I don't know, Judge Stucky, if you want to comment about that, about how did we come to the values Maggie's talking about?
Well, the framers clearly thought that if you didn't have a fundamentally virtuous populace, the whole thing wouldn't work. That if civic virtue wasn't dispersed among the people, and I don't mean any particular religion or anything like that. Civic virtue is an enlightenment thing. The idea of the people serving as rulers of themselves and therefore requiring virtue. If somebody else is going to tell you what to do, you don't need virtue. Hopefully he has virtue, but you don't need virtue. But if you're going to rule yourselves, you've got to have virtue of that enlightenment kind. And of course, the framers were all men of the Enlightenment.
Right.
And I think that's absolutely essential. I loved your reference to doing the ag bill, because of course you only had to do that every 5 years.
4 years, Scott.
Oh, was it 4? I thought it was 5.
It seemed like it was forever, but yeah.
It seemed like it was forever, and it took forever. But of course, the defense bill has to be done every year, and every year there'd be something. And you'd think, we're never going to get this thing done. And after you were there a while, and you were on the floor, and it was just painful, and you're sitting there forever in these hard benches around the perimeter of the chamber. Suddenly, one day would come, and all these amendments that everybody thought were so important would start to fall away, and the thing would speed up, and then bang, you were done. And it's different now. When I was there, the Senate still worked on comity and unanimous consent. And I didn't realize till I got there how different the two houses are. And of course, the framers intended that. The framers intended them to work differently, and they operated very differently. And with regard to legislation, the Senate still operates that way. I hope the Senate never becomes a double for the House, because that will do violence to constitutional structure. But the Senate operated on comity and unanimous consent, and the need to accommodate everybody, or everybody who was interested, forced people toward the center and forced them to seek agreement and forced them to seek compromise. If you only need 51 votes, you can ram it through. Well, then you don't need compromise. But when I was there and working for John Warner, who was a great man of the Senate, the two the two senators who ran the committee well, there was Senator Thurman the first 2 years, but I'm talking about John Warner and Carl Levin, both of whom were great legislators, great men of the Senate, who really fulfilled their constitutional responsibilities, knew what they were doing, and managed to get that god-awful bill through every year.
And the reason why I think we're talking about this, and I'm going to go to the questions from the audience in a few minutes, because some of them are directed just to contemporary things right now.
Yeah.
But I think what we're talking about is that, and I think for everybody in the audience to think about this, again, going back to if you were on an island with 100 other people, how would you organize yourself? How would you handle, again, to me, the key issue they dealt with, or at least one of the key issues, was power. Mm-hmm. They came from a monarchy, most of them, coming from that experience. So they were trying to consider, how do you you need power, we're forming a nation here. How do you disperse it? How do you check it? What we learned in high school about checks and balances is to me, the profound question about power.
Right, and they knew from the Revolution that putting out all the power in one branch didn't work. They knew from the Revolution that they needed an executive, that they needed some sort of independent judiciary, neither of which you had until the Constitution. So,
Maggie, do you want to comment about that?
Yeah, I think as I said, there's a reason why and we should, for all the participants who tuned in today, we should be sure to mail everybody a pocket constitution. There is a reason why the Declaration is attached to the Constitution. And I think it goes back to this point about the substantive values that really are animating this whole project. It's about dividing power, but it's also about certain promises and declarations that we made. And the Declaration itself, we focus on the beginning of the Declaration, but the end actually is really connected to what we're talking about today. The final sentence of the Declaration of Independence says, the signers say that for the support of this declaration, they mutually pledged to each other their lives, their fortunes, and their sacred honor. So it wasn't just a promise. It was their lives, their fortunes, and their sacred honor. And so what were they declaring and pledging everything that they had and everything that they could give to? And it's at bottom, it's three simple but really profound ideas. And the first is equality, that all people are created equal. And what does that mean? That means that a guarantee of equal justice under law. It's a promise, and it's a promise that we see every day in this country. We are working hard, and we have so much more work to do to live up to it. The promise of equality, but that animates the entire constitutional project, and it focuses our attention and our efforts on real values and real policies that because the NDAA, as you say, Judge Stucky, the Defense Authorization Act is one of the only bills that's passed every year. One thing that strikes me is the kind of civil rights and human rights legislation that finds its way into the National Defense Authorization Act.
There's no other vehicle.
There's no other vehicle, but it's an appropriate one, I think.
Yeah.
One of the pieces of legislation that I was proudest to work on when I was in the Senate was the Sergei Magnitsky Rule of Law Accountability Act, the Magnitsky Act for short. It's a very simple statute that I think captures almost, in very simple terms, the basic values of this country. And it's a statute that imposes sanctions on the worst human rights abusers in the world. It's now a global statute. Initially, it applied only to Russia and to Russian officials, but now it's a global statute. And passed as part of the National Defense Authorization Act. Securing the country and self, is actually at bottom about guaranteeing basic human rights. And as I said, we've got a long way to go, but this is, at least we know we have one legislative vehicle every year to try to make our union more perfect.
I have a question for both of you. One of my colleagues at the War College, Lonnie Cass, who was on the faculty when I was there,
Yeah.
mentions that in some countries there is no constitution. So Israel, she mentions, is has a obviously rule of law. Is it, what do you see the difference between having a written document and just shared values, shared history, shared tradition?
Well, there's more to take Israel. There's more to Israel than simply sort of, well, I mean, I suppose you could call it shared values, but Israel is a Westminster democracy. I mean, it's a single chamber Westminster democracy, but I think so much of Israel comes straight from Britain. You know, the founders, most of the founders of Israel sojourned in Britain at one point or another in time. Just like Britain has no written constitution, we say that, you know, they have a huge collection of statutes and uses, but I think a lot of what Israel's got came somewhat modified from Britain.
And would you say also, though, that commitment to process, let's say? Yeah,
commitment to practice. They obviously don't have a party situation like Britain does, but that grew up over time. So
go on, Maggie, because then I'm going to read a few questions from the audience.
I would just say on the written constitution versus unwritten, you know, I think that one thing we see today is, you know, a question you often hear, maybe this question's been asked by a viewer, is, you know, what do we do about the norms and values that underlie the Constitution that aren't written down? You know, do those exist? What do those mean? I honestly think that they are written down and they are captured in the oath requirements of the Constitution, that the basic norms and principles are there, but they're also embedded. You know, I think that there's an unwritten Constitution that certainly exists, and it's in the practices that we see. So for example, you know, the Constitution, you know, it's a compass. It doesn't give, it's not, it is not you know, Chief Justice John Marshall wrote famously in the Marbury versus Madison decision that this is a constitution we're expounding. It is not a document that has the proxicity of a legal code. It's not it's short, as we said, so it's a little over 7,000 words. But at bottom, you know, to be a faithful agent of the Constitution, to, you know, for the president to faithfully execute the duties of his office, and that faithful fidelity, the faithful execution requirement is both in the oath of office that the Constitution spells out for the president in Article 2, and then it is repeated once again in the take care clause, that the president has the responsibility to take care that the laws are faithfully executed. So, you know, the president has a lot of responsibilities under the Constitution and under federal statutes. One of them that we've talked, you know, we're talking a lot about these days is the duty to appoint, to nominate, and to make appointments to federal courts and to the Supreme Court. And it says it very clearly in the Constitution. Now, how that duty is exercised, to faithfully exercise your duty under the Constitution, requires that you understand history and that you see how others who are, you know, facing the same hard choices that our president is facing, how did they carry out their responsibility? And so that's why being a student of history is essential. And today, you know, I would have said that President Lincoln, you know, as usual, gives us an important model for how the current question, you know, of whether to fill a seat on the Supreme Court in the middle of an election, which is already underway. You know, 1 million Americans at least have cast their ballots in this election. You know, the only other example that comes close to this is, you know, not written out in the Constitution, but is part of our constitutional understanding, was President Lincoln when he faced 27 days before Election Day in 1864, a vacancy on the Supreme Court. His long and deep arch nemesis, Chief Justice Roger Taney, died 27 days before the election. And President Lincoln faced the question of whether it was proper, whether it would be a faithful execution of his duty to fill the seat. He had a Republican-controlled Senate. He could have filled the seat very easily. But he had to ask himself, is this faithful execution? And he answered that question, no, that it was improper under the Constitution to fill the seat. So, you know, that none of that is written in the Constitution, but to be a faithful agent and to uphold your oath, you have to know history.
So it underscores for me that we are an experiment, right? This is, we make it, we're evolving it as we go along. I know a number of people have asked questions from the audience about the contemporary issues that Maggie's talking about, a number of issues. Obviously, they're on people's minds. And that's why I think this conversation is good to ground us in the foundational issues here so we can all make our own judgments about these things. But from both of your experiences, what is the best way to again, in the idea of supporting and defending? Some people are concerned about the military becoming too political, or public servants who are civil servants becoming too political. I think a lot of us are drawn now to go back and read this document again, because we're debating it in some respects right now, right? Does this still work? Justice Scalia used to talk about originalism, that we should just stick to the words. So what's your sense about this time that we're in? And Judge, I'm not asking you to make any comments about a contemporary situation.
No. You know, you know where I can go and where I can't.
Yeah.
There's nothing in the Constitution that says flat out that the armed forces should be politically neutral. There's nothing in the Constitution that says flat out that we should have armed forces. And after the revolution, for a while, we basically didn't. But what they do say about the armed forces is that power, once again, is divided and diffused. The president is the commander-in-chief of the armed forces, of whatever armed forces we have, and the militia when called into actual service. But who decides what kind of armed forces we have and who raises the money? Congress. Congress has to do that. Congress makes the laws that regulate the armed forces. What can the president do as commander-in-chief of the armed forces? Well, can he get on his horse and go lead people in the field? Well, it would be kind of stared at today, but that's exactly what George Washington did in the Whiskey Rebellion. And as an ex-president, he got hauled back from Mount Vernon by John Adams to in the quasi-war with France, the XYZ affair and all that. But Maggie talked about this. There's more to the Constitution than what's written. There is usage, just like there is in England. There is usage, there is custom, there are things that grow up over time that people find useful, and therefore they survive. And certainly since the United States became a world power, you know, I suppose after 1898, and certainly from 1940 on, when the United States has maintained large armed forces in war and peace, the need for the political neutrality of those armed forces is, I would say, self-evident.
Yeah, I think, you know, so the question is, how do we think about the risks around pretextual or improper uses of the military? You know, and I think we could all agree that one clearly improper use of the military would be an effort by a commander-in-chief to use the armed forces to suppress the vote, to disrupt an election, or to create chaos.
And of course, there are statutes prohibiting that.
There are many statutes.
From Reconstruction.
Yes, so this is where I was going. You know, Judge Stucky pointed out that, once again, with respect to domestic uses of the armed forces, the Constitution is very clear in dividing power. The president is the commander-in-chief, but the president does not have the authority under the Constitution to call forth, and these are the words that the Constitution uses in Article 1. It's the power of Congress to provide for the calling forth of the military to execute the laws of the Union, suppress insurrections, and repel invasions. That's Congress's power at bottom, to call forth the military for domestic purposes. So Congress has enacted statutes, as Judge Stucky said. The first statute was enacted shortly after the Constitution was ratified, and it governed this instance of George Washington invoking what is known now, and it's more commonly understood today than it probably has been ever in American history, because our current president teaches us a lot about the Constitution. That is one thing I can say very positively about our president, that he has reminded us of a lot of things that we never had to think about, including the Insurrection Act. So the Insurrection Act was actually, if you Google it, you'll see Insurrection Act of 1807. It was enacted before that. But what the Insurrection Act says is it's Congress exercising its authority to call forth the military, and it is delegating, it is giving the president the power in cases of genuine emergency. So not a pretextual, self-dealing reason, but an actual emergency. The president can invoke the Insurrection Act. And so the most important example, and again, we come back to history, the most important example of the use of this act and what it teaches us about the purposes was to enforce, actually. So the Supreme Court decided, it's, in my view, the most important decision of the Supreme Court, the decision that reminded us for the first time that actually the promise of equality in the Declaration would be made real. This was Brown v. Board of Education in 1954. So the Supreme Court issued a unanimous decision, 9-0. The implementation of that decision, and this again comes back to power and how it's split up. The Supreme Court does not have a militia. It does not have a military. The Supreme Court relies on fidelity to the Constitution and willingness of the participants in our constitutional system to listen to its decisions. And this is an existential concern for any, thinking and breathing Supreme Court justice, that the people may not listen to what the Supreme Court has to say. In this case, in the case of Brown, it was a very close call because the Supreme Court spoke, but the leadership of the state of Arkansas and the city of Little Rock did not. And so what we had was a decision before President Eisenhower about how to respond to that. And what he did was he used the power under the Insurrection Act to call forth the 101st Airborne and to enforce Brown v. Board of Education and to enforce the principle that all men are created equal. And so that is how the military is used domestically, to enforce civil rights, to enforce human rights, to enforce and make real the promises and the values that animate our system. It's not used pretextually for self-dealing or to violate those rights, like the right to vote.
And Scott, do you remember when you were in JAG school, when you were doing your legal studies in the Air Force, was that what you were taught? Is that your understanding of the proper role?
Candidly, they didn't spend much time on that. They didn't spend near as much time on it as they spent on how to give an Article 15 to to a screw-up troop. They should have, but they didn't. It was too much nuts and bolts.
Explain to everybody who's not in the military what Article 15 is.
Yeah. Non-judicial punishment for minor offenses. But does it have to be inculcated? Absolutely. More today than ever. The role of the armed forces is a constitutionally conscribed role, and we better keep it that way. You know, the armed forces, if you can keep them, to phrase Franklin.
Yeah. Well, let me just look at for a minute. Somebody asked me, there's a question from the audience about the Pledge of Allegiance. We don't pledge allegiance to the Constitution. So where did that come from? That's not back in colonial era.
That came from a magazine article in about at the time of the Columbian Centennial, about 1892, and it's gradual. The original one was a lot shorter, and it's gradually sort of attained shibboleth status, but it has no constitutional foundation whatsoever. It's a pledge to the flag. Of course, the flag has no constitutional foundation whatever, although it's certainly been the subject of some litigation. But the Pledge of Allegiance is really a totally unofficial thing, except insofar as legislatures or folks like that try to.
What I remember about it, because I remember this coming up in class, actually, at the War College, talking
Did
about
it? Yeah. Well, of course, the notion that you pledged allegiance to the flag is a first thing, when the Senate convened. They didn't do that when I was there. That's something that came along. I don't think they did that when I was there.
Well, what I remember about it, and Maggie, you want to talk about it, because I'm trying to remember the history of it.
1942 is when the Pledge of Allegiance was put into statute. But Judge, respectfully, I actually do think there's a constitutional basis for it. So the oath is about supporting and defending the Constitution, but bearing true faith and allegiance. And so, what does that mean to bear true faith and allegiance? I think it actually does speak to the ideas, but to the rituals that we create as a country, expressions of.
I think that's fair.
And here, with the Pledge of Allegiance, it's even just think of, what is it that it says? Pledge allegiance to the flag of the United States of America, but we're pledging actually, even more importantly, to the Republic for which it stands. One nation under God, indivisible, with liberty and justice for all. I mean, it was the 1942 edition, and really but what, to me, the power of the Pledge of Allegiance is the fact that it's actually pretty recent in our history, that we've continued to find ways over the past 230 plus years to keep alive, to keep the true faith and allegiance alive, and to find expression and ritual around that. And I think that is it's so important. And one of the for me, like a goal, a project for anyone out there listening, and for both of you, that I'm really interested in, is finding civic rituals that will resonate, that are written for the times. So that's what the Pledge is so exciting to me, because it's so recent and it's an inspiration.
So recent, but it's become so affected, so accepted rather.
Yeah. And I think, as I remember, it does go back to what Judge Stucky say. It was in that earlier period when it started. And as I recall, and it's a good example of how our country has adjusted and absorbed the various pressures we've gone through. Yeah. Sometimes we sell ourselves short. We've addressed major challenges as a nation. And one of them at the time, as I recall, is that that period in the 1880s, and I forgot what you said, Scott, when the article came out.
I think it came out about the Columbian, 1892.
It was a time of massive
great exposition in Chicago and so forth.
But it was a time of massive immigration
massive immigration.
And so Italians, Polish, Central Europeans, it was a great wave of immigration. And what I remember, because I looked at when I was trying to get the history of it myself, that as the nation, as people who were involved in this absorption issue of all these people coming, we're struggling with a similar question that the framers did, which is how can we now, we're absorbing all these more people, how can we keep cohesion, keep people together? And so the pledge in part was focusing children on something they could see, but then as Maggie talks about, weaving into it the values of what they want indivisible, that we couldn't be divided into parts.
I am so old that when I was a first grader, they had just put under God in there. And older people always stumbled over it because they forgot to stick in under God. And then it was about 3 years later that they put in God we trust on the dollar bill.
Mm-hmm.
But
I think this goes to, what's written on our printed money. What we're taught to say in schools. I mean, and I'm just so struck and moved by the photo that Martha showed at the beginning of all of this, that these words and ideas, we have to find new and creative ways to embed them into our souls, really, because what's so powerful about the oath is what's so powerful about the Constitution, that it is about, it's a leap of faith, but it is a project that has got to sustain faith. And so how do you sustain faith in one nation united for these lofty ideas? And it's in small and big ways that we have to continue to be creative and entrepreneurial to bring actually what's the best about the American spirit to bear and in civic education.
Well, we're running out of time, and of the people who've submitted questions, we'll get answers back to you in writing, because a lot of you have asked very thoughtful questions that would be a whole nother discussion, because there's so many things on our plate. I just want to conclude my part of this by thanking both of our speakers, and just a personal comment about this. When I was much younger, beginning of my career, I lived in a country that went through a military coup. And I remember thinking that the day after this happened, that liberty was so fragile because it was gone. It was just gone. It had been a constitutional republic. This was in South America. And with all the things where it was a parliamentary government, but it had courts and everything else. And the next day they were gone. And it made me so respectful when my students at the War College would say, how did I tolerate Capitol Hill? All that compromise and talk and grayness, how did I tolerate it? And I always would go back to that, because I appreciated liberty and the protection of our Constitution so much that when you lose something and you get that visceral feeling of no protection, no law, no structure, that I just want to end with that, in that right now in our country, we have people honestly on the right and the left both saying they want to fight to protect and defend the Constitution. And I think that our Institute for Civics Education would recommend to both sides that they read it.
And vote.
But yes, read it, but study it. And as a teacher myself, read it. And yes, participate in all of our wonderful aspects of our democracy. So Martha, thanks so much for letting us renew good friendships here and engage our audience. Thanks so much.
Thank you so much to Janet Breslin-Smith, to Chief Judge Scott Stucky, and Maggie Goodlander for your really profound statements this afternoon, for your gifts of time, expertise, and leadership. I just wanted to remind everyone we have one additional treat webinar planned for this fall on October 29th, also at 4 o'clock to 5:15. We will host Michael Rebell, a Columbia professor and attorney who argues that civic education is a constitutional right. He and his co-counsel, Jennifer Wood, will discuss why they're suing the state of Rhode Island for lack of civic education. If you would like to participate, you can register at nhcivics.org. So good night all, and thank you very much for being here and for your interest in civic education and its impact on our nation's civic strength. Thank you.